Before I get started, obviously I want to thank all of you for being here, particularly to our panel of speakers and to our moderator. It's quite intimidating for me to be starting off this session, given the great wealth of expertise that all of our other speakers have. So I will do my best to earn my seat on this table. Very briefly, my role is to paint a brief picture of the work that the CMN is doing in investigation and fact-finding. We have a toolkit called the Investigation and Fact-Finding Toolkit. For speed, I'm going to refer to it as the toolkit throughout the next few minutes. Perhaps, Olympia, I can ask you when I get to around 12 minutes, point at me, and it will remind me where I need to be in the presentation. But very briefly, as I think both Ilya and Olympia have done in their own presentations, I want to summarize some of the observations or assessments that we have observed in documentation challenges that national criminal justice actors face in conditions where possible core international crimes have committed, as well as some of the accountability options. This in part also reflects our experience in the last 3 years of working with two different actors in Mexico. I also then want to really spend the majority of the time introducing the IFF toolkit and its database IDOC, which aims to structure and minimize several of the existing challenges of fact work in national systems, particularly I think where there are multiple accountability options on the table. And then if I have time, I will very quickly summarize our work in Mexico, if it isn't already evident from the presentation, before we pass on the floor to Jose. So there are, of course, several challenges, or there are multiple challenges in investigation of fact-finding work. Several of them are similar to case mapping, selection, and prioritization, and they don't always come into play at the same time. Oh, I sped forward through two. I was going to start with conditions. So typically, I think documentation work can begin in multiple iterations and by multiple actors in real time or in recent or distant time periods after the violations happen, and in all three of the above options. There is often limited standby capacity by different accountability actors, not just public bodies, but also NGOs, or other documentation bodies, which, as we've seen with the ICC, the role of other information providers has perhaps grown in importance and significance over the years. There's also often uncertainty over the potential scale or nature of the violations, and quite typically insufficient legal or operational frameworks that allow the documentation or investigation to start off perhaps in the most optimal way. And these two factors often can cause quite considerable challenges or difficulties in the startup phase or throughout the documentation process. And of course, significant security risks. If we turn to some of the responses in these typical conditions, coordination becomes an issue amongst different fact finders. It may take time to develop, it may never develop. You may question why, in fact, there needs to be coordination. There's also inconsistent collection and analysis methodologies, which can limit the availability of coherent, accurate information on the scale or character of the offenses. And I think those of us who have been following work in Mexico can also reflect on that, on this as one of the types of challenges that are faced. There are any number of documentation efforts of different databases and procedures that have been implemented by a number of different bodies, and there has been some challenge in reconciling the breadth of that information for any number of reasons. Fact work strategies take time to develop, particularly to accommodate the scale and complexity of the conduct, and also the different legal and evidentiary frameworks that different accountability options require. And of course, there may be piecemeal or infrequent investigations and prosecutions by authorities, partly as a result of these conditions or of many other conditions that may come into play. Consequences, I think we are quite familiar of, which may typically be a limited number of cases being investigated or pursued, confusion or skepticism, mistrust over the type of information that's available, and so on and so forth. And one then of the patterns that we do observe frequently are complaints to the ICC, which may or may not be fully substantiated according to the framework that the ICC operates in. Oh, I didn't put it up on the board, I'm sorry. If we move to perhaps the desired outcome, again, something that is pretty obvious and straightforward. Readiness for structured and compelling documentation. This is one perhaps goal or outcome. Fact work being able to begin at the earliest possible moment, taking into consideration security issues of the actors involved. Increased awareness and engagement of the different types of accountability options and what that really involves. Competent fact-finding and investigations, coordinated strategies for accountability, including public discourse, and multiple but coordinated accountability options which can be matched by robust monitoring. So if we look very briefly at the types of accountability options that may be on the table for national actors, you can see them spread around the board from the ICC, UN human rights systems, national procedures, both human rights or criminal, regional human rights systems, ad hoc tribunals, and transitional mechanisms. Each of which has its own legal evidentiary framework and policy considerations which structure the types of offences, the level of responsibility, the standards of proof, and the submission process. And if we look of those accountability options that require individual criminal responsibility, you see that the options become somewhat limited. One example perhaps of the differences in the legal classifications can be found, yes, it works, if we compare the ICC with the Inter-American Court of Human Rights. So we see the differences between the classifications, both of the crimes, the responsibility, and the types of proof that is necessary in order to trigger investigations or criminal trials or processes by those two institutions. And I think particularly in Mexico, our experience has been focused on these common elements of core international crimes, specifically of crimes against humanity, and aiming to develop engagement and capacity on what that actually means in a Mexican context. So very broadly in our work are the toolkits, as by now you may be quite well aware, composes of three things: a database, publications, and services. Now the purpose of the toolkit really is to rationalize the preparation and delivery of core international crimes or gross human rights violations, the documentation of those two potential offenses or legal classifications, through to ensure that the most appropriate documentation can be submitted to different accountability mechanisms, including but not restricted to the ICC. The database supports fact work for different accountability options. Publications support the relevant strategic challenges facing fact work, including outreach or dialogue between national and international actors. And the services support these areas through workshops, trainings, mentoring, or technical assistance. Now, the methodology of all of our toolkits is up here on the screen. We adapt them to the different working languages of the partners or the actors that we work with. They're customized to the specific legal frameworks. If I give an example, in Mexico as a federal system with 32 states and then the federal system, we see that databases can provide a very useful tool through which to structure a very wide range of laws which have often don't share the same classifications or components. We also provide them without cost to the user or the partners. In this case, we're able to do that through the funding we receive. This particular project is made possible through the European Union and the Norwegian Ministry of Foreign Affairs. And in addition, we also offer mentoring where required to support that early phase work and engagement of national actors with the toolkits. Okay. I'll slow down a little bit. If I turn briefly to the IDOC, so the IDOC is the database. It's an investigation documentation system. That its full dull name, and we refer to it as IDOC in short. And it provides a methodology to collect, analyze, and conclude fact work that different actors may choose to engage in. It does so through a tried and tested structure and also by addressing fact work methodologies. And I think at this point, I should acknowledge that this is primarily the work of Ilya Utmelidze and with contributions through the years by Alexander Sidorenko, who is somewhere here. So they have really driven the technical construction of the database. And it's people like myself and Andrea at the back who have been implementing and unfolding it in different countries under their watchful guidance. But going back to the database, it obviously allows you to collect, obtain, and verify materials, to analyze, corroborate, summarize, and synthesize, and also to structure and organize a very rich arrangement of different types of documentation, and then provides a number of different outputs to support the types of activities or actions that users may want to do with use them for. And we can show it a little bit like this. So you begin with a document repository, any number, or the document collections that may be already in the custody or possession of the organizations that we work with, which obviously can include any number of types of data that is registered according to a fairly solid metadata structure, where you can then create and construct analysis and linkage based on a number of different functions or categories, from witnesses, victims, suspects, incidents, context, involved organizations, and even protected objects. And the outputs that the database then supports can include fact-finding, a variety of different catalogs, involved organizations, and it also supports the progression to different types of cases, be they human rights cases or criminal cases, according to the specific legal frameworks that our partners ask us to customize the database for. If we start perhaps with an example, if we look at, or we consider persons and the multiple roles or dimensions that a person or an individual may play in any potential core international crime situation, you can understand that a person may be either a victim, a suspect, or a witness, or all three. Now, the IDOC provides a way of being able to register the metadata of that individual as a person, but then also to create linkages to the different categories they may have within any particular context or incident. So that can include, for example, information or data can be linked to show the role of that person as a victim or their victimized status in a number of different incidents. it may also be able to show that that person themselves is also a suspect in another type of, in another incident, and that they may also have been witnesses to further incidents. Now, this slide is something that Ilya and I constructed last night. You see our design capabilities are significantly different, or lower, we should say, to Andrea, who prepared these slides. But this is really another way of being able to show the linkages between different incidents, where you can create, say, a cluster of victims that may have been involved in a particular incident, witnesses, protected objects, and then connect, in this example, suspects to other suspects, military units, and additional incidents. So in that way, you can create a kind of a visual map of the fact work that is being conducted. Perhaps another way of showing some of the role or the purpose of IDOC is also to pull together and structure both context, incidences, and the suspects who may be involved in that general pattern or general set of data. So finally, I think I'm doing quite well on time. I wanted to finish shorter than 20 minutes so that the rest of the speakers could engage us a little bit more. Some of the associated difficulties that we have, or that this type of process engages or has to deal with, can include the willingness to share information. Now, this is particularly clear with civil society actors, but it can also be found amongst different public bodies or criminal justice institutions, where they are required to share information amongst one another in order to pursue or further investigation activities. Harmonization of methodologies is another significant challenge or factor when dealing with different institutions or organizations, and also the importance, I think, of having an effective implementation plan which has clear procedures and processes for everyone who's engaged to pursue. And then I think consensus on who uses the information and how to use it. These are just some, perhaps, of the challenges involved in this perhaps more collective documentation work. But beyond this experience, other actors are also fully open and invited to use IDOC where it may be relevant for them, including state institutions, NGOs, public bodies, and other institutions with fact-finding mandates. So now I will very briefly introduce one example of the deployment of the toolkit, in this instance in Mexico. Now, as Jose Guevara is going to speak very shortly after me, I will keep it brief, but I will simply say that since September 2014, we have been working with Jose's organization, CMDPDH, to customize the IDOC and also to support and strengthen their engagement with the definition of crimes against humanity and also their documentation work in that regard. A little bit later, we also concluded a slightly separate agreement with CEAV, which is the National Victims Commission, to support them in creating a historical victims registry using just a small component of the IDOC. I think one of the core or two core areas where we see, which we see as necessary in building or generating the engagement and also capacity to engage in a slightly different type of documentation work in Mexico. It's been through consultations with national actors and workshops and outreach, where we've worked in partnership with Stanford University, Berkeley University, and others in the California catchment area, as well as CIDE in Mexico City. I think perhaps one of the particular challenges that Mexican NGOs have faced is in making this transition from documentation of gross human rights violations according to the inter-American system, and then kind of transitioning into potential core international crimes. And I think perhaps in this regard, we can observe the recent report by Open Society Justice Initiative, which I think made a significant step in going to the next level, so to speak. And I think it's useful reading for each of you if you haven't yet come across it. Finally, I think to conclude our activities in this particular round of the project with our Mexican partners, there will be a series of mentoring activities starting, well, they've already started, but they will intensify between August and November, when Andrea will hopefully be based in Mexico City to oversee a small team of analysts who will be working under the direction of the Mexican Commission of CMD-PDH to document a certain set of materials that we are discussing with them now. And I would like to acknowledge also Lucia Chavez from the Commission, who's here with us for the conference in the next couple of days, as one of the leaders in Mexican NGO world pursuing these sorts of activities. I'm probably actually up to 20 minutes now, so I'm sorry I got carried away, but on behalf of our core team, most of whom are up here on the screen, I would just like to say thank you very much. If you recognize any faces here in the room, it's Ilya, myself, and Andrea, and you'd like to know more information, please corner us after the event. We'd only be too happy to answer your questions.